abuse and misuse is so enormous in the newly fortified UAPA that it's it's bringing us back to that whole tada pota kind of days. These two sort of horrendous draconian legislations, Quota, Prevention of Terrorist Act, and Terrorist and TADA. So both of these were either scrapped or allowed to lapse by because there were campaigns by human rights activists saying how draconian it was. It's interesting to see how low the conviction rates of both of these laws were. I mean, these were specifically anti-terror laws.
1.5% and 13% is the other one.
As low as that. So, so the point that human rights activists were making was that the whole idea of these anti-terror legislations was not to convict, but really to keep people in prison as long as possible. To that was what one was seeing at that time. And despite the fact that all of these anti-terror legislations were allowed the loosening of the due process. You had admission of confession as evidence and so on, right? But even despite all that loosening of due process, still the conviction rate remained so low. So the human rights activists, civil rights activist groups had made that point, and slowly it sort of gained currency even within the political circles, and both of these laws were lapsed. But now what happened in when the UPA, the first Congress-led government came into power, and that was one of the major agendas that was on its manifesto, was the scrapping of POTA, Prevention of Terror Activities Act, which had been brought in by the previous NDA regime, the BJP-led NDA regime. Now, when it was scrapped, what happened was that the UAPA, the Unlawful Activities Prevention Act, which had been there since 1961, however, it was strengthened and fortified. So, I mean, by some sort of pernicious means, people didn't realize it at that time, but many of the provisions of POTA and TADA were brought into UAPA. Now, both POTA and TADA were special laws in that sense that they had sunset clauses, so they had to be reviewed periodically. Yeah. Now, UAPA is an ordinary law. It's not an extraordinary legislation, it's an ordinary legislation. Now, many of these provisions of extraordinary law were actually brought into what was deemed as ordinary law, which need not even be reviewed after a period of time. So you had, and there have, since 2004 at least, there have been several amendments to the UAPA Act. And with each amendment, it's been further strengthened and the rights of the accused have been further eroded. But at the heart of UAPA has been, this whole issue of conspiracy and suspicion. So, the clauses say that you conspiring to execute a terror act, right? Yeah. So an actual terror act may not have to be there in order to prove somebody's connection to something. Yeah. You can just say that conspiracy and that act you've got a sleeper cell before they could actually execute an attack. So really very little evidence is required. The burden of evidence goes down further. And the most recent amendment, which has just been passed in the last session of the Parliament, they've brought in new clauses into the already very stringent UAPA. Now, the bail provisions are very stringent. It's not easy. The remand periods are very long. The bail provision says that if the magistrate or the judge feels that on prima facie there's a case against the accused, then he may not grant them bail, which is very, very loaded against the accused. And this is what happens in all UAP cases. You know that just now these two, the journalists and the DRDO scientists have just been released after spending 6 months in jail. They didn't get bail till about 6 months. That is because prima facie the judge may have felt that there was an involvement. So people don't contest bails. The lawyers of the defense lawyers are actually very hesitant to go in for bail because they know that it will be rejected. The bail application will be rejected. The magistrates and the judges are inclined not to grant bail because it's a question of national security and who's going to bail that cat. And again, just like as in TADA and POTA, you have long periods of incarceration, trials which fall below the standards of fair trial standards, acceptable universally, and the lowering of burden of proof. In fact, repeatedly, despite despite the loosening of due process and evidence standards and so on within these trials, you find periodically, routinely, the prosecution says, "Oh, but why do you need proof beyond reasonable doubt?" why not convict this person for much lesser? So, I mean, all this is happening. But now the latest amendment, what it has done is it's brought into the purview of Terrorist Act economic offences, which is very, very dangerous. You know, for example, one of the clauses says that if you were to raise money from India or from abroad, which could have been, which may not have, but which could have been used for terrorist acts, and you knew about it, then you could be convicted for as long as 10 years or life. So, you know, people, you know, all organizations, NGOs, people's movements, civil rights groups, local groups like you raise money for madrasas and schools and so on and so forth. People raise money. Now, to use this pretext to say that, you know, oh, you could have used it for anti-national or seditious activities. You don't necessarily need to show that a terror act.
It's not beyond a reasonable doubt. It's within a reasonable possibility.
Yeah, I mean,
you know, it's like
see,
inverted.
Again, suspicion and the fact that you knew, that knowledge, you know, it's very difficult to establish in a court of law. The fact that you had knowledge of something, right? It's difficult to establish in a court of law. But the point is that you will probably be incarcerated for 10 years before the court decides that, oh, there is no substantive basis to say that you had knowledge of, you know, the fact that your money could have been used for terrorist activities. So the scope of abuse and misuse is so enormous in the newly fortified UAPA that it's, I mean, it's bringing us back to that whole Tada Pota kind of days. What happens is when people are arrested or when people are picked up, more likely, because arrests are illegal you know, aspect. People are usually just picked up, detained for days and so on. But when the media starts to report on these arrests and detentions, the line usually that the media toes and what the public accepts is that, oh, these were terrorists who were picked up, who were busted in some great operation by these forces, and now they will, you know, be arrested, you know, charged with under anti-terror laws and so on and so forth. There is very little critical questioning on part of either the media or the general public. So, you know, because of our involvement with the Butler House encounter since 2008, and we've been following various cases, we, you know, we've been compiling over the years cases in which people were acquitted. We used to, you know, look at the newspaper reports, which usually would say another LET terrorist let off, not really looking at what the judgment was really saying. So we were compiling these cases, and we decided to put them all together because the point here was to look at what the courts were saying, not just, you know, what human rights wallahs were saying, which is, you know, their word against the police's word. But we wanted to look at what the courts were saying. So, and what we found was, you know, that there was a pattern to which these police forces were working, especially investigating agencies who specialize in the task of anti-terror operations. So, you know, one found that people were usually picked up much before they were shown as arrested. And these are all things that courts have established. We're not saying that, or just the accused is not saying that. You know, the courts have established. For example, you know, in one case, a person was picked up on, say, day 1, and he was arrested from his home. I mean, he was just picked up illegally from his home in somewhere in Western UP. And his brother and wife sent telegrams to the local police chief. They sent telegrams to the NHRC. They sent telegrams to the president and whoever they could, right? So there was record of, you know, that there was that documentation to prove that this man was actually picked up much before. But the police were claiming that, you know, he was picked up arrested much later. So these were the kind of things that we brought out, that people were illegally detained, and obviously they were illegally detained, and, you know, one doesn't need creative imagination to know what the police must have done to them while they were illegally detained. So they were disclosures which were favorable to the police version were extracted from them. And we find that, you know, all the legal requirements of any operation were not adhered to. For example, the need for public witnesses. That was found to be wanting in all of these cases. The police would routinely say that, oh, we went for this operation, but we asked the general public to join us, and nobody would agree, and so they all ran off, and so we were forced to, you know, conduct this operation all by ourselves. But repeatedly the court said, you know, it's very unlikely that you were doing this near, for example, near some government office, and you could have easily got somebody from the government office to come and, you know, be a witness to your operation. So, I mean, this was one thing, that desire on part of the police to avoid any sort of independent public witnesses, the reliance solely on police witnesses or on police officers themselves who were supposedly the part of the operation. Then again, the complicity between the police officers here in Delhi police and, say, Kashmir and the military intelligence Kashmir or the IB or police in Manipur. In one case, we know, for example, it's been documented in our report that one of these, military intelligence officers in Kashmir wanted to gain promotion and medals for having gotten some militants surrendered. So he got in touch with one man. The man refused to help him out, and this man was a tea trader. So he would come to Delhi routinely. So when he was in Delhi, in order to teach him a lesson, the military intelligence officer from Kashmir conspired with the Delhi police officers, and they picked him up, and they sort of implicated him in a false terror case, right? And so I mean, this is kind of things that you see flouting of all norms, all set procedures, all due procedures in the name of nobody would join us and so on and so forth. And even things like, for example, if you're going out on an operation, ideally you should take your police vehicle, because then that's a kind of a record that you went out and you did that operation. But we found that in most of the cases, except a few, the police would say that we went out in private vehicles. So there's no way actually you can even verify the log records of the police vehicles that day to check if they actually went out or not. So the use of secret funds. So there is a general kind of a miasma of an opaqueness to all their operations, which doesn't allow accountability or
Seems like arbitrary yet systemic abuse.
Absolutely.
Both at the same time.
Absolutely. The point in one of the cases that we looked at, in fact, the judge was very severe. He said that the case, there must not only be a departmental inquiry against these police officers who not only framed these people but who actually dramatized the whole. I mean, there was a non-existent police encounter which they claimed to have conducted. So the judge is very, very, very strict. He says that this entire encounter was scripted sitting in the office of the police station. So it never did happen. Right? So he says that an FIR must be filed against these police officers and there must be a departmental inquiry, and this must be done within a month's time. So after the lapse of 1 month, we actually sent out an RTI inquiry to the police headquarters saying, what's happening, citing this judgment and saying what's happening to this, has there been any departmental inquiry and has the FIR been filed? So the response that we got was that no, we're not doing anything because these police officers have gone into appeal against the verdict of the Sessions Court. They've gone to the High Court. I mean, this is all fine. They may go as individuals to the High Court to appeal, but as a police force, as an institution, surely you must be accountable, and it must set you thinking. That such a severe and stinging indictment by the courts, that must set you thinking. There was no the police force did not feel any need to conduct even a departmental inquiry because on the pretext that these men had moved the High Court. And this is not just this case. I mean, there have been other cases. For example, there was a special cell police officer, SS Rathi, who was similarly indicted in a fake encounter. And in fact, he continued to serve in the police force even after he was convicted. He wasn't even suspended. And it's only when the High Court intervened and said, what are you doing? You have to suspend him with immediate effect. Then the police was suspended. I mean, they said, he's gone in for appeal, so how can we suspend him? So there is this, some people would say that, they're just a case of some bad apples in the police force that, and if they are some sort of, tinkering with the system, then maybe we can have better, but I think the case is, I mean, the rot is much more deeper. It's become totally institutionalized. This arbitrariness, this abuse.
And then passing on the responsibility after something.
It's institutionalized. It's absolutely institutionalized. And I think that needs a complete overhauling as far as.
And I think this is you mentioned this with the UAPA.
Because
and maybe it's similar to this, is that you can't improve these systems. You can't humanize them. You have to repeal them and start over in many ways.
And especially with anti-terror, just as with anti-terror laws, the immunity that is granted and afforded to the army, for example, under AFSPA. Similarly, what we're seeing in this so-called war against terror is that, these, whether it's greyhounds in Andhra Pradesh or whether it's ATS in Maharashtra and elsewhere and special cell in Delhi and so on, there is a certain kind of impunity that they're afforded in the name of national security. It's something that, these are small compromises that one will have to make. In fact, several leaders have said so. When after the infamous Anchal Plaza encounter, I think it was during way back in early 2000, I think 2000, 2001, can't get the time right now, but the NDA was in power at that time, and Deputy Prime Minister L.K. Advani made that speech that, expect some compromises on human rights, because what we are up against is, this...
It's an ancient bell that's being rung.
Yeah.